You're listening to the Privacy Casebook Diary.
And in each episode, we discuss and review a data protection case or matter.
We hope you enjoy the content we share.
And hopefully, you'll learn and grow together with us.
Hello, I'm Cristina from CVG Solutions, and I am a data protection professional working primarily with small and medium organizations, including charities.
Hello, I'm Michael Mulholland, and I work with Spencer West as a data protection and AI regulating specialist.
So apologies, everybody. I have a nasty cold. You probably can hear it in my voice. Michael will probably do most of the talking, but I will, participate as much as I can. Now, this is a case that Michael and I have already reviewed in the past prior to pressing the record button. So this is where we were having, our weekly get-together and just discuss case laws, and then we decided, well, why don't we share these with a wider audience so that they can also benefit from it. But this is a very interesting case, and so that's why we've decided to revisit it and this time record it so that we can share it with you. I now hand over to Michael.
Okay, so the name of this case is Harrison Cameron, and this is a 2024 High Court decision, and it's a very colourful case because it concerns a landscape gardener who has a firm, quite a large firm. He's over 20 employees, doing work for a business which deals with commercial property, and that led to a dispute. And where the soap opera element of it comes in is the exchanges that were made via telephone calls or video calls, probably by an iPhone in a car, which recorded a transcript of the exchanges, which were
rather colourful.
So the dispute arose around a contract, and so Mr. Harrison felt that the work had not been completed to his satisfaction. He felt that Mr. Cameron was not following instructions, and so he summarily terminated the agreement and said that you had 6 o'clock to remove all the tools from the area what he's working on. So quite a large contract. I mean, we're talking hundreds, over £500,000 worth of business. So, that was the background to it, and maybe you want to say a little bit more, Cristina, about it.
Yeah. So
having read it, yeah.
So what's interesting is that these conversations that have been recorded by Mr. Cameron, who is the gardener, are quite colourful because Mr. Harrison is making certain threats, or so they are perceived. Which kind of starts the entire case. And this recording are then shared by Mr. Cameron to family and friends, and also with some employees. And so this then leads to Mr. Harrison losing a bid in the purchase of a large commercial shopping centre. So Mr. Harrison feels that obviously this has done reputational damage, and so that's why the whole case starts. And so he then asked for copies of the recording, but also the names of the recipients of those recording. And Mr. Cameron's sort of says, well, these were used and shared in a pure personal and household facilities, and so they are exempt from the UK GDPR as per the exemptions in Article 2. But then it then proceeds to share the same recording with a number of employees. And he does so as the director of ACL, which is the gardening landscape company. And so those are not in the pure household personal purposes. And so those would be, so in that case, Mr. Cameron or the company is the controller. But the judge also says, well, when he shared these recording with family and friends, he also did as, you know, as the director of ACL, not as, you know, a person in a pure household, because he did share them from the company phone. And when they were recorded, they were recorded as him as the director of ACL, not him as Mr. Cameron, the individual. So that's sort of the background of it and the facts. It's actually quite interesting. Do you want to add any more to that, Michael?
Yeah, so for me, it's just a case where we're looking at DSARs and what hangs on it. So the property developer, Mr. Harrison, once he got wind that his calls were being recorded, he made the DSAR. So he wanted to know who the calls, what calls were recorded, the categories, and to whom. So he was particularly interested in who the calls were made to. And of course, Mr. Harrison, Mr. Cameron had shared the calls with his family, and he shared it with his employees, and he shared it slightly further afield with friends. And the calls also made their way to business interests, which this is what Mr. Harrison, he felt he's lost a huge multi-million pound contract for the development of a shopping centre. I mean, it's a warning as well. It's one of those that you're on a call with somebody, you don't know when the call is going to be recorded, and potentially anything can go viral nowadays. And this didn't quite go viral, but it did reach a large population. So once the damage was done, Mr. Harrison was look at trying to find out, well, actually, who's this gone to and why. So from his perspective, he's probably thinking, actually, there's some purposely disseminated recordings of this call that's gone to people that probably ought now, with the intent to damage my reputation and to undermine, my business interests. So the purpose of that DSAR then is DSAR should be about an individual looking to claim from a controller what personal data is held, but it's also this thing's around, where it oversteps into the discovery field, and it's actually this preparing a case, and potentially there's going to be sort of quite hostile legal proceedings against those recipients who may have received the recordings quite innocently. So quite rightly, Mr. Cameron felt that actually, if I disclose who the recipients are, those recipients could receive the sort of similar treatment. It was very menacing. It was the treatment they received on the call it was made quite clear that there's from a third party, me reading the transcript is like, actually, this is threatening, this is menacing. And even Mr. Harrison said himself that actually it made him look like a gangster. Well, he's using sort of a language that is consistent with that. My friends in Manchester will pay you a visit, that sort of thing.
Yes.
So again, it's just around a little. I mean, there's some basic things about the aside from the legal issues that are brought up there, and what on the particular GDPR issues around what is controller, and what is used for family purposes. It's just the practice, and just you should
Yeah, but the
always be
other thing
careful in your
that
communications. Yeah.
yeah, but the other thing that it sort of highlights for me is so when Mr. Cameron was recording this conversation, which the judge has established, or in the case established that he was doing so as a controller because he was using the company phone and he was, the conversation was in connection with, the commercial agreement that they had, that Mr. Harrison was actually terminating, and therefore it was in the pure business context. So I think Mr. Cameron, acting as the director of ACL, should have actually informed Mr. Harrison that he was recording, because he wasn't, done in a pure personal setting. It was, like the judge said, it was a commercial conversation. And so Mr. Cameron should have informed, as per Article 13, Mr. Harrison that he was recording it.
Yeah. I mean, I mean, there's two sides to every story, isn't there? So, and
Yes.
in this one, Mr. Cameron, there's some wording that he used that indicate that I knew I was winding him up, and I wanted to capture the nature of the man
Yeah.
for maybe for future purposes, because he wasn't going to get paid. He's worried about there's at least I don't know, 50 to 150,000 maybe a ride. Still at dispute. Plants were delivered, which were worth 50,000 alone, and
Yeah.
so there's quite a significant amount of money there. So again, he was probably planning actually to say, well, this guy's been unreasonable, and then they're probably anticipating that there could be future legal proceedings. So again, it was evidence gathering. So it's highly unlikely. So you are aware, that I am recording this, so you want to temper
Yeah.
your conversation. So that's not going to happen. Yeah.
Yeah. So yeah. So I can't remember
So,
then how it ends though, Michael. What does the judge says at the end? I can't remember.
well, again, I think this is about the scope of a DSAR. So, as his
Because
capacity, as he owns a company, so
because
Mr.
because he
Cameron,
because Mr. Cameron does release the recording in the end to Mr. Harrison under the DSAR, but it doesn't tell him who he's shared it with.
that's right, that's right,
Um,
yeah, and for good reason,
yeah, because he wants
because
to protect them.
it's the balancing test, isn't there? So there's like the default position is like, well, it's like he's acting as capacity director for the company, and his company is a data controller. What was made clear then, he's the agent of the company. So when he's performing his actions, then he's the agent for his
Yeah.
landscaping business, and is acting as controller. He withheld the the names of the recipients, because he felt that their rights and interests
Yeah.
would be prejudiced by disclosure,
Yeah.
and the judge in this agreed with that, because on the basis of the evidence and the character witnesses. So Mr. Harrison came came across as not a reliable witness, and that the language was used was clearly menacing and threatening, and
Yeah.
there was the risk that the same behaviours could be applied to the recipients. So to withhold those persons, third party persons' data, and their identity then was appropriate in these cases.
Yes.
So that was it. So yeah, you had to consider the rights and the freedoms of others.
Yes.
So that was confirmed. So you consider the proportionality as well. So it was protecting their interests of those third parties was right and proportional in these
Yes.
circumstances. And overall, it was considering like the cases of Durant, and it's you shouldn't be using DSARs as part of legal warfare and litigation gathering. It is for the uses of finding out what data is held about you. from the controller. So it clarified some good things around what's the limits between a domestic, like a family case which referenced linguist. So
Yeah.
so it was, and so that was that argument fell apart. It wasn't accepted that it was just because it's a further dissemination to the employee. So it wasn't for household interests. It was clearly for the business,
Yeah.
and they acted the business as controller. So I think reading the judgment of the case, there's very little that you can disagree with in terms of how it's practically applied. And that was one of the things. It's not just strictly legal. Yeah.
I like the fact that the judge sort of, has taken a really, step by step, each sort of argument, if you want, put in front of him, his or her, I think it's a she, she really does go through, very methodically, and then she refers various sort of other case law that she's taken in for helping her to make the final judgment. So it's a real thorough judgment. So it makes some really interesting reading.
Yeah, and it's just I think go back to basics. Then it's just you've got to be careful about your reputational risk. Control your emotions, and you never know. I mean, we cannot know for sure, but there was some evidence that was mentioned in there that they did play a part in the loss of the shopping centre contract.
Yeah. I mean,
there's reputational risk for the people selling the interest in the shopping centre as well.
I mean, the parties that were representing the selling of the shopping centre, who then were not favoured for Mr. Harrison, but Mr. Harrison already had a bad reputation, and the fact that they came into contact with the recording just simply reiterated that the reputation.
That's right. Yeah, that's right. Yeah, and the industry they're in was quite like data protection world is quite a small
niche. Yeah,
people know each other in these niche industries, and the same in that property world there up in the northwest.
Yes.
So so there's a salutary lesson there.
Yeah. Right. Hope you enjoyed listening to this, and by all means, do go and read it, because it is a really good, interesting case. Thank you for listening. See you next time.
Okay. Bye.